Our next panel is going to address the opioid epidemic and current marijuana laws. Populating this panel are Dr. Charles Reznikoff with the Addiction Medicine Program at Hennepin County Medical Center, and two of my Dorsey colleagues in the Labor and Employment Group, Nicole Burgmeier and Jillian Kornblatt. We'll give them a couple of minutes to set up here. But one of the things I just wanted to touch on with the previous panel is, the word thoughtful was used several times. And as a woman construction lawyer, who's been practicing exclusively in the construction industry for 25 plus years, it isn't uncommon for me to be the only woman in the room with, 25 guys, and they're either lawyers or construction executives. And similarly, I travel mostly with men, for my practice, which is a national-based practice, so I'm often on the road. And, as a woman, you want to be included, but you also, from my own perspective, thoughtful things when you travel with somebody. There's things as a woman. I will never enter, a male colleague's or a client's room. I will never have them in my room. Likewise, if I'm with my clients and there's a group of them that after meetings all day like to go to the bar, it's my one and done rule. I'll have one and then I excuse myself. So it's you want to be included, but you also have to understand that, there's certain things, don't put yourself in that position. And I've had great male mentors. I've had more male mentors than female mentors. The industry is changing and there are more female construction lawyers. But, that opportunity for mentorship is so important and it's so valuable, and everybody in this room, can say that they are where they are today through a strong mentor, whether that mentor was male or female. And I think it's really important as we, look at the millennial generation and say, the thing that they're telling us more than anything else is they want everything to be inclusive. And inclusive means mentoring and training and being champions. And Jim, I know the CEO of Alte, and there's a guy who invented the word champion. And so, again, as we look at this Me Too movement, I hope the pendulum doesn't swing too far where all of a sudden we cut off the opportunity for mentorship. So I'll get off my own personal soapbox now and set up the next panel and hand it off to you guys.
Well, thanks for having us. Today, as our session says, we're going to be speaking about opioids and marijuana laws. I'm a healthcare attorney here at Dorsey, so I'm going to start with just providing a really brief overview of the current status of the opioid epidemic throughout the nation, and then we'll kind of move down and go into kind of the medical aspect of it and some of the employment aspects. So I always like to start with this slide. Who's involved when we think about the opioid epidemic? Because we have a tendency to kind of think about it from our own perspectives. I know I do. As a healthcare attorney, I get a lot of, my clients are pharmacists and pharmacy benefit managers and manufacturers and distributors, but it's really important when we're looking at it as a whole to think about everyone that's involved. And so you can see there's so many different players, and I think that helps us understand why you're seeing all this news and maybe a lot of discussion about are we doing enough, are things moving quickly enough. It's because there's so many different actors and everyone's coming at it from different standpoints. And one of my favorite quotes is from Judge Polster, who is, and I'll talk about this, there's a very big litigation going on right now. It's a multi-district litigation, very akin to the tobacco litigation that we've seen in the past. And he says, everyone shares some of the responsibility and no one has done enough to abate it. And that's kind of why we're here today, looking at what can employers do to help their employees who are suffering from substance abuse. So here I've kind of outlined some recent news developments, and this is really a quick snapshot because this has been in the news for a while now, but it's really picked up steam. We see initiatives happening both at the federal, the state level, private industry, and then the litigation. So in October of 2017, the Trump administration declared the opioid crisis a public health emergency. There's a lot of discussion about what that actually means. Is that enough? That was for 90 days, and it was extended by HHS until about April of 2018. And in Congress, there's also been a lot of money that's been appropriated to fight the epidemic. This year, about $6 billion has been passed so far to address opioid and mental health crises. But again, there's a lot of discussion about, even though we have all this money, is it getting to the right groups? Are we doing the right initiatives? So at the federal level, that's a lot of the discussion that's going on. There are, last I saw, 63 different bills going around that dealt with the opioid epidemic. So it's really something that's caught a lot of people's attention. At the state level, there's also a significant amount of initiatives. We have states looking at collecting data on opioids. They have task force. There's been passages of Good Samaritan laws. A lot of focus, probably within the last year or two, on the prescription drug monitoring programs. And I think the states are doing and our panelists can jump in, but I think they're doing a really great job of working together and trying to be creative in solutions. And that's not something that's necessarily possible right away at the federal level, so the states have kind of stepped up to take that on. We have private industry initiatives. We have insurance agencies, companies, PBMs looking at refill limits, lock-in programs, prior authorizations. Prescribers are using pain management. Contracts, we have education, and then we have litigation. And here is a summary of the litigation. So what's interesting when you sit down to look at this table that I've put together is most of the plaintiffs and defendants in this litigation are the same actors in the first table. And so if you think about why we may be having some issues coming up with great solutions, is that we have a lot of people involved that are trying to work together, but they're also all being sued by each other. So it creates this very unique dynamic of what to do. And these are just in the past few years kind of the general plaintiffs and defendants and claims that we see. And there's a lot more going on. So how does this all tie into the construction industry? What I thought was interesting when I was preparing for this presentation was I was reading a lot of articles that the construction industry was really at the forefront of this crisis because, as you can see from the statistics, about 15% of construction workers have a substance use disorder from the Midwest Economic Policy Institute when they did a survey. And so it was really, the construction industry was seeing this problem before it actually became kind of in the public eye because they had their employees having substance use problems. And in 2015, this survey also found that 1,000 Midwest construction workers died due to opioid-related deaths, and you can kind of see the numbers. The highest number was in Ohio. So it's a really big problem for the industry. When I was talking about all the initiatives that were going on, one thing you may notice is I didn't say, Congress or states were looking at employers. That really hasn't yet been a focus. They haven't given great guidance as to what can employers do. We can limit the amount of pills that a practitioner may prescribe. We can have all these other type of safety things put into place, but what can employers do? And there hasn't been great guidance, but I'm starting to see that change. The U.S. Senate Committee on Health, Education, Labor, and Pension is one of the committees that has a bill out right now of the 60-some. And in their bill, they actually do address economic and workforce impacts of the opioid crisis. They kind of look at it from a different angle, and they're saying, if someone has a substance use disorder, they'll probably be fired, they'll probably go through treatment, and then once, they've gone through treatment, how can we get them back in the workforce? So they're looking at it from that point, how can we retrain them, instead of looking at it from how can we keep them employed and help them get treatment. But one of the best resources I've seen came out, I think, last month, and it was the Ohio Chamber of Commerce, and it's not that surprising given the numbers. Ohio has a pretty big problem with opioids at the moment. They created an opioid toolkit for employers. It's free. You can just go to their website, and it has great resources, videos, some handouts, and just a great place to start for employers to think about it from their standpoint. What can I do to help my employees? And then from the construction industry viewpoint, there's a lot of unions in your industry. They have been pretty involved doing collective bargaining agreements. Some have offered through their unions employee assistance programs. And last month, the Teamsters of Ohio and West Virginia were the first unions to join the multi-district litigation. So that litigation is based in Ohio, takes and consolidates a bunch of different federal cases. And essentially, it's a large number of groups suing drug manufacturers and distributors, saying that they did false advertising, marketing, they weren't monitoring the distribution of these pills enough. And the Teamsters said this has cost our union just an astronomical amount of money as we've had to treat our members as they go through substance abuse treatment. So what do we usually see for suggestions for employers, since, as I said, there's not a lot of great hard guidance at the moment from the legal standpoint? We see recommendations to incorporate substance use disorder and mental health treatment in your health care coverage, limit opioid dosages in your health plans, kind of train and educate your employees on alternative options rather than opioids if they have some injuries, provide employees with sick leave, paid sick leave, so they can go and get treatment and stay on top of their bills. We see about temporarily assigning workers that are using opioids to low-risk duties. And if your state law allows it, and Minnesota does, but you would have to look at where your employees are on the job site, you could have naloxone on site to distribute and if there was an overdose on the construction work site. And another thing that we have a lot of discussion about is drug testing and employee policies. I think Jillian was going to talk a little more about that.
Hi, my name's Jillian, and I'm a labor and employment attorney. I work with Ryan and Melissa, who are just up here on stage. And so I'll set the stage. Nicole said earlier that states are taking a lot of action because the federal government can't or isn't. That's true across all of employment law these days. So I think the last panel was talking about how you have employees who may be moving to job sites in different locations. So one thing to keep in mind is if that's where they're working, that state's employment laws would apply to them during the time they're there. The state where they're based may or may not also apply, depending on how the statutes are written, but it's a patchwork and there's very big differences, so that's one thing to keep in mind. Drug testing, Nicole has on the slide, termination for first-time offenders may not be the best approach. I guess the good news is if you're talking about employees located in Minnesota, that's not a decision you need to make because it's not allowed. Minnesota has one of the most highly regulated drug testing, employer drug testing laws in the country, more even than California. It's a technical statute. We could spend a whole hour on it. One key thing is that you have to have a policy in place and have provided that policy to the employee before any drug testing happens. So if you don't have drug testing and you're thinking about it, make sure you do the order in the correct way. I've seen a lot of employers decide they want to do the testing and then think about the policy on the back end. Under the drug testing, I'm not going to go through the whole regime, but if there is a positive test on the employee's first test, they have to be given the opportunity to go to rehabilitation before any termination occurs. And one issue that's become complicated with the advent of legalized marijuana is where does that fall in the scheme of things with recreational and medical marijuana. So Minnesota is also a little different here. Minnesota has one of the most restricted of the states with medical marijuana laws in terms of what is available, but it's one of not too many states that have included built-in protection for individuals who are in the medical marijuana program if an employer does drug testing. So that medical marijuana here has decriminalized medical marijuana. So employers can't discriminate against employees who have a positive test or are on the registry for medical marijuana. That doesn't impact what you can do if it's recreational marijuana use, which is not legal in Minnesota. But those are kind of some considerations to think about in the drug testing realm.
Great. Well, that's all I had, so I'll pass it off to Dr. Reznikoff.
Okay, well, happy to be here. Thank you. I am an addiction doctor and a general medical doctor at the county hospital down the road, and I work at University of Minnesota. And I also do outreach to Rice County, which is a small kind of rural county an hour south of here. In addition to that, I work with the state on Medicaid recipients, regulating prescriptions to Medicaid recipients. And I've been involved in writing some guidelines. I work with the state on the medical cannabis program, so I'm a little bit of a jack of all trades. But I will say, actually, unprompted, the real hot topic now is state legislative action about opioids. And there's a variety of things moving through the Senate and the House. And but the thing to know about, and you can decide if you want to do something about this, there is a bill in the Senate which will reach a vote that raises the licensing fee to distribute pharmaceutical opioids in Minnesota. There's a licensing fee already, but it's nominal, it's $200 to make hundreds of millions of dollars distributing pharmaceuticals, a nominal fee. And boy, the Senate is trying real hard to get the pharmaceutical companies to contribute in some way to treatment for addiction, and they're fighting back hard. And so it's been round and round on how you may have heard of a penny per pill tax that got shot down. But this idea in the Senate is going to come to a vote. Anything that comes to a vote on this is going to pass because politicians know that the people of Minnesota believe pharmaceutical companies should chip in. But on the other hand, the pharmaceutical companies are influencing as much as they can to prevent it from coming to a vote. So the House is a real question, whether there'll be a vote on an increased licensing fee on the pharmaceutical companies and pharmaceutical distributors to distribute opioids in our state. Why do I say that? One is you could ask more about some legislative actions that are happening statewide and nationally on this, and we can talk about that. And two is if any of your clients or if any of you yourself have a strong stake in it. It helps particularly Republican members, politicians, to hear from industry that they support it. Because right now they're hearing from the pharmaceutical industry that they're against it. So if you want to be involved at all, let me know. I know the key players and I can connect you. That's just a plug. That's off topic. On topic, my brother, Joe, 10 months older than me, we grew up like fraternal twins, is a union welder in another state. And he drank too much, but he actually then got sober. So he was sober. And about 6 years ago, he broke his foot. I was already an addiction doctor at this time. He broke his foot. He's prescribed opioids for his broken foot. On the job, he broke his foot. And I was staying at his house, and one night at like 3 a.m., he woke me up, shook me awake from asleep, and he told me to go to the garage with him. And he started crying. My brother does not cry, and said that he believes he'd gotten addicted to the Percocets that he was given for his broken foot. And I was like, I'm not my brother's doctor. I'm my brother's brother. And so that was obviously complicating. But 4 years, 5 years, he was out of work for a full year, all sorts of treatments, all sorts of struggles. He is Now, he's sober. He's back at work. He's actually a safety manager now at a construction site in Milwaukee. And without his wife, without his parents, our parents, and I gave some advice as well. I don't think everyone gets the kind of support he had when they had the problem he has, but he's through it for now. He's in recovery. And so when I come and talk to you about this, it's somewhat personal as well as professional. So from a professional point of view, this slide is old. The percentages don't matter, and it applies to all addictions, but the concept I want to get to you, which is that for someone with an addiction, there are sort of different phases they can be in. They could be incarcerated. They could be out in the community using their drug in an addictive way. They could be in rehab, or they could be in the community sober, like my brother. My brother's actually been in all phases of this cycle, and there's a sort of a natural cycle between them for any given individual. And it's interesting to know that for anyone in any given box, it's most likely that 1 year later, they're still doing what they were doing a year ago. So people in recovery tend to stay in recovery, and people in crisis tend to stay in crisis. And the whole point of my work is to get as many people into that green box as possible, back sober, in the community, working, back with their family, etc. And so that's kind of what I'm talking about, and that's what the medical community is trying to do, is trying to shift the flow of these patients from these different areas towards recovery. This is a classic study of opioid addiction that spanned 40 years, and it was 600 male heroin addicts from the 1950s. This would apply equally to pharmaceutical opioid addicts, but when it discovered these 600 heroin addicts in 1955 or whatever, it enrolled them and followed them through the rest of their life and asked, at each year, what are these people doing? So they lost track of 12% of the patients, which is pretty good. 88% followed through. And what they found is that if you're a heroin addict, even 40 years later, only in this study 22, you sometimes see 20, you sometimes see 25, but this has been repeated, and in the low 20s percentile range, do people with opioid addiction sort of walk away and go back to their life, right? So about 20% of heroin addicts, opioid addicts, get to just walk away clean, and 80% are affected and an ongoing for over decades of their life. And that's premature death, and those deaths are not natural deaths. They're premature deaths, accidents and overdoses, etc. Incarceration, ongoing drug use. And so this is, compare that, for example, to marijuana. Many, many young people smoke weed excessively when they're 21 years old. 85% spontaneously walk away from marijuana. So with marijuana, 15% have a hard time walking away. With opioids, 80% have a hard time walking away. So it's a disease that really sticks around for your life. It's 60% genetic. I'll just sort of leave it at that. It's one of the more genetic addictions. And what this means is that two identical twins split at birth. They do these twin studies, identical twins, genetically identical, but they're split at birth for whatever reason, adopted. If one is addicted, the other, who grew up in a totally different town, different family, has a 60% chance to also be addicted to opioids. And I see an incredible amount of mother-son, sibling, family pairs. You know, I see many family pairs that come to my clinic, and then once they get sober, they bring their relative in as well, which is an interesting dynamic. But very genetic disease. This is a study recently published that looked at 2,500 opioid addicts and asked, what happens to them? And it followed them for 8 years, and of those 2,500 opioid addicts over 8 years, 20% died. And by way of comparison, that's really bad. That's like cancer or heart failure. The death rate from opioid addiction is incredibly high. It's a couple percent a year. As an aside, you all probably hear these awful statistics about 60,000 Americans died from opioid overdose, or whatever it is. 50,000 Americans died from opioid overdose. More people die from opioid overdose than car accidents. More people die from opioid overdose than AIDS at its peak. You hear these statistics? Understand that death, 60%, that's so shocking and terrible, that represents probably 2 or 3% of the total at-risk population. So we think it's shocking, but it is a fraction of the people out there at risk. So each year, only a couple percent of these folks die, but it builds up. So over 8 years, you get 20%. Methadone maintenance programs and buprenorphine, also called Suboxone, commonly called Suboxone, programs lower mortality threefold. So this is a study of 200,000 patients, and those on methadone and buprenorphine are 1/3 as likely to die. A way to think about that earlier, this study is 20% walk away, basically unassisted by buprenorphine or methadone. If you add buprenorphine or methadone to the mix, you're up to around 70-75% can walk away and regain their life. Methadone and buprenorphine doesn't cure addiction, doesn't get you to 100% of them are sober, doing great, but it takes a 20% chance and increases it to a 75% chance. So methadone and buprenorphine have a stigma, and I will say, as I do both methadone and buprenorphine, doing both, we're waiting for a better treatment. We're waiting for a cure. We're waiting for less side effects to a treatment, less regulations to these treatments. But right now, it's the best we got, and it improves their chances from pretty grim to much better. On methadone and buprenorphine, they aren't yet like normal people. There's still a higher risk of death. Did you have a question?
Yes, I did. I was going to ask, is that treatment typically covered by insurance plans, and is that something employers can think about making sure is covered in their insurance
Yeah,
plans?
no, I think that's a critical point, and there's one more medicine I'll mention next, and then I'm almost done with my comments. And a critical point is making these treatments available. Methadone maintenance programs, if you look at Medicare, it is total patchwork across America, who gets methadone and who doesn't. If you look at buprenorphine, it's both, most people have access to buprenorphine through a standard insurance plan. Some insurance plans don't. I take care of dozens of union construction workers. Almost all have access to buprenorphine without a hassle. One had an insurance plan that didn't cover buprenorphine. I'm not sure if that was his union or his choice of his options, and he chose poorly. However, buprenorphine sometimes they grant you coverage, but they put a bunch of barriers. Prior authorizations, the PDMs, can put barriers or obstacles between you and accessing the medicine. That can be a deterrent. But you're right. Insurance plans that cover these treatments are going to be really important and will not cure, but improve the odds of the person recovering. This is one of many similar studies that show the top line. This is retention in treatment, so it's just an example. Retention in treatment, and the top line is people who are offered these medications, and the line that falls off, everybody's just walking out of treatment, are the people who are not offered these treatments. So that's 1 year. A 1-year retention, if offered medication, is very high, meaning even if they're not perfectly sober, they're at least engaging. And the 1 year, the 50-day retention for someone not offered medications is basically 0. They all walk away. So offering medications really keeps them engaged in treatment as well. Quick slides. This is a cost-effectiveness study done in California that looked at California used to have a policy because we don't want to hand out methadone too quickly because it's so problematic and stigmatized. So they had this policy that if you got addicted to opioids, you first had to go to counseling, and then you had to fail that. So you had to fail a non-medication treated therapy first to qualify for addiction. So this was a study asking, what would the state of California save if they just put them straight into the medication treatment? And it's $80,000 of saving per patient. You're delaying 6 months as they are highly likely to fail. And then they cause all sorts of expenses to the state. And this is just an estimate of an opioid addict out there on the street basically creates $50,000 of expense for his or her community every year. They get into all sorts of problems, and they have all sorts of needs. So there is an expensive group of people. There are other benefits besides just keeping people alive and sober. Pregnancy outcomes, incarcerations, that's a really important one that's known. Lower incarcerations by offering them medications. less HIV, Hep C, et cetera. I'll take questions on this, but just to remember, methadone is a full-strength opioid that needs to be given in a directly observed therapy clinic. So our methadone patients come in every day, see a nurse face-to-face, have a drug counselor they can access every single day, and they get observed drinking their methadone dose. It's observed therapy. It's a lot of structure. It's a lot of accountability. Methadone's a serious drug, though. It's heavy, right? Buprenorphine is a partial opioid. It's not full strength. It's about 40% strength. It's a lot safer, and because of that, the regulations are less. It's not directly observed therapy. They can go home with a bottle and take it on their own time. And the third one is called naltrexone. Naloxone is a Narcan, but there's something called naltrexone, which is an injection in the muscle of your butt. And if you get this injection once a month, it totally blocks the opioid receptors. So even if you tried to, it's not a narcotic itself, it's not intoxicating in any way. Even if you tried to use opioids, you wouldn't even feel them. I call it, excuse the expression, it's sort of the chastity belt for the opioid receptor. Even if you tried, you couldn't gain access to that receptor, right? And so that's a once a month injection in the muscle of the butt. That is newer, and there's less evidence, but it also works. It's a good option. And for those in Minnesota, this is a website about state resources, and I think that's it. So I appreciate your attention.
Yeah, and throughout, we're going on very different topic to topic here, so ask any questions as they come up. Please don't feel like you need to wait until the end. None at the moment. Okay, yeah, thank you. So I'm going to talk about disability accommodation, because that is the bucket that a lot of issues related to an employee with who's using drugs or who's in rehabilitation from drugs. That is the most relevant statute in addition to the drug testing that we just talked about. So the Americans Disability Act is a federal law that requires accommodation for disability. There are also state laws. The Minnesota Human Rights Act is the one here in Minnesota, requires accommodation. It doesn't have a requirement of 15 or more employees. So under the ADA, individuals who are protected with regard to drug addiction are those who no longer are using drugs illegally and those who are receiving treatment for drug addiction or who have been rehabilitated successfully. The ADA does not protect an employee who is currently engaging in illegal drug use. Here, as I mentioned, the ADA is a federal statute. The Minnesota medical marijuana and that regime is a state law. There's some interplay here. Federal courts across a lot of states have held that even medical marijuana is not protected under the ADA, but if your employees are in Minnesota, you would defer to the medical marijuana statute is the most conservative path there. And the medical marijuana would be legal, other uses of it would not be legal. So that's the framework. So your employee who's actively using an illegal drug is not entitled to those protections, but an employee who is receiving or has received treatment who may need accommodation, and the most frequent way this is going to come up is they need accommodations to go get treatment. Active use does not require accommodation. So an employee who's missing work or coming in late due to active illegal drug use, there's no protection for that, and you can take action as you would with any other employee who's having those kinds of performance issues. The disability-related inquiry, that is something that may come up in this context if you have things going on in the workplace that makes, say, a supervisor or even other workers wondering if there is something going on. And you as the employer need to ask questions to find out. So if the individual seems unable to perform the essential functions of the job, or I think more critically is someone who could pose a direct threat to themselves or others. And so in a lot of industries, that's not going to come up if you're working in an office, but in your industry, that is a very real concern. And so you do have the right to inquire what's going on with the employee if there is feedback you're getting that suggests that something may be unsafe. But you can't just for no reason go around asking employees about their drug use or other medical conditions. So what we are, one thing that we want to avoid is a failure to accommodate claim based on someone needing treatment or rehabilitation. So these are kind of the criteria that someone would have to show to bring a failure to accommodate claim. So the qualified employee with a disability, and a few slides back we talked about what is covered and what is not covered there. The individual made the employer aware of the need for an accommodation, and we'll talk a little bit about how an employer can be considered to be aware. And keep in mind, an accommodation includes, and one of the most frequent accommodation is leave from work. So whether that's for a 30-day inpatient treatment, or I need to be gone every Tuesday and Thursday afternoon, or I need to switch my schedule a bit, those are all requests for accommodation. And then the final step is the employer would not have engaged in the interactive process to determine whether they could accommodate the employee. So those are the three main areas that you need to be aware of. So what qualifies as a request for accommodation? So the employee needs to make the employer aware of a need for accommodation. But there's no magic words here. They don't need to say, I'm requesting accommodation pursuant to the Americans with Disabilities Act. You know, it may be very simple. I've got a problem with drugs. I need to go to treatment. I need to go into rehab. I need to detox. I need to make my meetings. Something like that is enough. They don't have to use magic words. One thing that's really important is to have a policy in place so that employees know who to request an accommodation from, and that it should be someone in human resources if you have an HR department. A lot of times you'll see a situation where the employee may think they've told the employer, they've mentioned it to coworkers or a supervisor, but maybe HR or higher level management has no idea that this is on the radar. So it's important to spell that out on the front end so they know where to go. Also, employers can be on notice even if a request is not explicit. So say you have an employee who's acting a little erratically, their attendance has changed dramatically, then they don't show up for a while. You may be, you know, if there's enough going on that coworkers, supervisors have an idea that there may be some drug use involved, you wouldn't want to go ahead and terminate an employee for just not coming in. You'd want to take a few steps and find out, are they getting treatment? Are they in detox? A lot of times, and you'd have a better sense of it, but employees aren't able to communicate in the way they normally would when they're in those situations. And I've had a situation where an employee just kind of went missing, and she turned out to have been in a treatment setting where she couldn't communicate. So you want to take that step to be a little more proactive if you have any kind of notice. Self-identification could come up. You know, there is stigma around this issue, so it's not as likely people will self-identify. But if they do, then it's important to follow up with them.
Can I make
Please
just
do.
a comment that there's a federal law adding additional privacy protections above and beyond HIPAA for addictions. So a patient who's in detox or in addiction treatment, there is a series of releases they need to sign if they choose to allow us to speak to anyone, to the point where when I'm writing return to work notes, I have to inform my patients that just my name signed at the bottom of that note, even if I make no allusion to the nature of the disease or the visit, they could Google my name or internet search my name and determine me to be an addiction doctor and therefore infer the patient's disease. So it is the privacy around addiction is highly regulated. This patient's primary care doctor would not even know. Doctors down the hall from me on the same electronic medical record cannot see my notes. So even within institutions, there are firewalls to prevent addiction notes to be seen by other providers. It's not always a good thing, but it's a highly protected thing. And I can get you the federal law on that if you want.
Right, so that makes making sure this is going through human resources all the more important. So you always want employees' medical information to be going through HR, someone other than the direct supervisor. The direct supervisor, of course, needs to know they're not going to be here for medical treatment, but you don't want to have the supervisor getting information from the employee or in any other way to the nature of the treatment, details. That is always something you want to keep separately, not in the personnel file, but in this situation, even more so for those reasons. So as I touched on quickly, and I'm going through this pretty fast because I want to have a little time left for questions, but the interactive process, that's the place where courts are going to look at to see if the employer did what it could. The standard is that employers need to provide accommodations unless doing so would be an undue hardship. Undue hardship is a sliding scale. So if you work for a large company, a lot of financial resources, what you're going to have to do to make accommodations, much different than a tiny family-owned business with a few employees. So that is something to keep in mind. As I said, leave is almost always viewed as a reasonable accommodation. So there is no requirement to reassign an employee's essential functions of the job on an ongoing basis, but temporarily for leave, temporarily to accommodate treatment. You know, your jobs that we're dealing with, a lot of them in this context are jobs where you have to be present. You have to be present during work hours. You can't flex your hours so you're working late at night or early in the morning when no one else is there. So it makes a lot of these accommodations trickier than the average office worker who can, you know, leave early one day, make it up the next. So it's something to really engage in conversations and think about what you've done for other reasons. So if you have allowed employees to, say, leave early to, you know, a hobby, their children's sports schedule, if they're coaching a league, if it's a commute issue, whatever the reason, you're going to have a very difficult time making the case that it would have been an undue hardship to allow the employment getting treatment to leave early in those situations, or come in late, or take a long break, whatever it is. On the other hand, you know, the fact that the job is so hands-on and needs to be done in conjunction with others is a real concern. So it's tricky. Leave for a set period of time, say a 30-day treatment program, is actually a little more straightforward because you can usually find other people to cover the work. Even if that means hiring a temporary employee, that would still be considered a reasonable accommodation. So depending on the skill set, that may be something that you're expected to do, to have engaged in this in a good faith effort to accommodate. However, what's not required is to let misconduct go because of active drug use or illegal drug use. So you don't have to ignore an employee's misconduct, even when it's coming up. So threatening another employee is not protected activity. Issues with interpersonal relations, difficulty, stress, lashing out, not taking safety precautions, coming in late, leaving early, just going missing, all those kinds of things you can still address as a performance issue. And going back to what we were talking about with the Minnesota drug testing, if you're in a situation where you have reasonable suspicion to do a drug test based on those kinds of behaviors, and you do a drug test and it's a first-time test, it's positive, you do have to offer the opportunity for the employee to go to rehabilitation. However, if you don't do drug testing and you're solely basing your decisions on the employee's work performance, which can include any of those things I just listed, you don't have to do that chance for rehabilitation. So you can just take action based on the performance as you otherwise would. So, you know, if you don't already do drug testing, and I'm guessing a lot of you do because of the safety issues, but there are some advantages to actually just addressing the behavior you see rather than trying to do the drug testing. But there's a lot of reason, obviously, to do drug testing in safety-sensitive positions, so that changes it. So those are limits on what employers need to do in those situations. So a few more thoughts on practical guidance on top of the ones Nicole already mentioned. If you have job descriptions, carefully identify your essential functions. These are going to be looked at if there's an issue that comes up. Remember, on-site attendance can be an essential function, and that may be so apparent to you because, of course, it needs on-site attendance. Make sure you put it in the job description. Put in the hours of work, the importance of working when others are also at the work site, so the work can be done in conjunction. Make sure that you note what's essential, because those are the kinds of things that you would not be expected to take away or move on a long-term basis. Again, if it's a shorter term, leave is certainly reasonable. The hours of the job, if there are safety issues related to those essential functions, putting them in the job description can also help you down the road if you do need to take action. Document accommodation requests in the interactive process. It's really important to keep a record of these. I have been advising employers generally, not just in this industry, keep a record of accommodation requests and your responses to them. We are seeing the EEOC and the Minnesota Department of Human Rights now, when somebody has a disability accommodation, failure to accommodate, charge of discrimination, those agencies are asking, what other accommodations have you provided in that same working unit or even across the company? So it's a good idea to keep record of those. And those also help you make sure that you're not providing accommodations in a way that's disparate. So you don't want to have a situation where maybe people of one gender are provided more accommodations, or race, or there's the ability for someone to say, hey, this wasn't provided to me because of my race, gender, sexual orientation. That's the basis of a separate claim that can come up. The other thing that's really important is to make sure supervisors are aware that they can't make comments or act in ways that can be viewed as retaliatory if somebody has used accommodation. So if somebody's had an accommodation of leave for treatment or a schedule change for treatment, you don't want the supervisor to make comments referencing that, giving them an extra hard time if then they have an attendance situation that's more run-of-the-mill. They have a cold, child sick, something like that, not, hey, you were already off 30 days, now you want to come in sick late with a cold, that sort of thing. That can be viewed as retaliation. So you've got the basis to get extra claims built in on top of the underlying accommodation one. And if you're not able to make an accommodation, make sure you've got a really thoughtful reason why you're not able to do that, convey that to the employee, and document the reasons you weren't able to provide the accommodation. And make sure, again, the people who need to know about the accommodation are informed not of the underlying reason for it, but what's happening in terms of the employee's schedule or other accommodation. But in this topic, it's usually scheduling that's going to be the primary issue. And 3, and I touched on this a minute ago, really give thought to all accommodations. Make sure, the immediate reaction may often be like, no, we can't do that, just because it hasn't been done before, but really give thought to whether you can do something to shift resources, bring in somebody temporary, move job duties around a little bit. It's really important that you're, again, not showing it would be a hassle, hard, cost extra money, but the undue burden, which is a pretty high bar. And 4th, we talked, don't inadvertently penalize the employee requesting the accommodation. Again, make sure that their supervisor's aware of the comments, what work they're given. You don't want them to be in a situation where they're not being given opportunities they otherwise would have, pay, travel for jobs to different job sites. All of those things can be construed as retaliatory if they're treated differently because of the accommodation. And that's all we had on our slides. I wanted to leave some time for any questions. Yes, we have one in front here.
I have a question. It's been many years since we've worked in Colorado, but I could see that coming in the future. And we do drug testing.
Mm-hmm.
System pretty quickly, state have limits beyond which people are considered to be impaired. But marijuana is really different. It stays in the system for much longer, and I'm not sure that there are limits that have been established to determine when someone is impaired or not. And so I would just like to hear more from the panel on, are there limits? Dr. Reznikoff, is there a point where someone is impaired from marijuana? I'm trying to think about how we should address that when we're going to be going to Colorado to work. Not here in Minnesota, but going
Right.
to a state where it's permitted.
Yeah, that's a great question that I'll repeat. So the question is, if you're going to be doing business in Colorado, but the list is growing of other states that have recreational legalized marijuana. And the issue is, unlike alcohol, where you know someone's used alcohol very, very recently, if they test positive, marijuana can stay in the system for, I'll let him answer, but I think like a while, a month. And can you set any sort of limits on that, and how do you work with that to gauge whether someone's been using marijuana and, I assume, been impaired during work hours, which some employers want to take a zero tolerance policy, some just want to make sure the worker isn't impaired during work hours. So, Dr. Reznikoff.
Thank you for the question. As you probably know, a lot of knowledge and infrastructure is built up around alcohol testing. So it is straightforward to understand how recently and how much you drank and how much that is likely to impair you, and the variance between different people's alcoholics versus someone on the first drink of their life. We understand that to a high degree of certainty. There's a lot of uncertainty with marijuana. I'll say a few comments. One, impairment, meaning likelihood of occupational hazard, is very high for 4 hours after use, and then falls off after that. Impairment, meaning memory impairment, amnesia, short-term memory loss, is probably 3 days, and then falls off after that. So different forms of impairment, both of which are relevant to you all, are going to fall off at different timelines. And drug screens for a single one-time use may only actually be 3 to 5 days, but for heavy, persistent use, maybe 30 days. The military, in the process of recruiting soldiers, did a lot of studies to understand what the marijuana in their urine drug screen meant for those recruits. And a lot of actual information has come out about secondhand smoke. I was at a concert and someone smoked next to me. You know, like things like that. So there are answers to those questions, but you need a toxicologist to help you with some of those questions. But the deeper answer to your question is, we don't have the infrastructure to determine how recently this person's used and how impaired they are. The only tool that I would suggest, which you probably can't use, is what police use, which is an actual clinical assessment, do like a roadside sobriety test. So police will have experts forensic experts that can determine whether you're impaired in this moment. The drug tests, et cetera, are not yet reliable, so I'm not sure that helped, but you are correct, it's an issue.
I have seen case law, I believe it was out of Washington State, also has legal recreation, where employers set a number of the blood, I guess, marijuana level, and that approach was upheld in court. Does that have any bearing on it?
A lot of people are working on blood levels. There's even effort to work on the equivalent of a breathalyzer. From my point of view, we're not quite ready for prime time on that, but it's happening, and I think in 5 years, there's enough need for it that knowledge is coming, but I don't know that I would not trust it today for a variety of reasons. Actual impairment is the most important thing, because some people smoke marijuana and aren't impaired. Some people smoked a lot a week ago and it's still in their system versus a little just now, and those levels may look the same, but the impairment may be different. So it's complicated, it's still complicated.
Yeah. And legally, in a lot of states, you can still go with a zero tolerance policy. I realize in some states that may reduce your applicant pool fairly significantly. So I don't know that that's a sustainable approach, frankly. And employers may need to move to something more like a sobriety test or old-fashioned judging the performance, training managers to look for signs of actual impairment and problems in job performance. It's a good question, and one I think is going to be more important as time goes on.
I'll make a comment.
Yeah, please.
And then one of the things in terms of misconduct I thought of is there is a lot of sharing of pharmaceuticals on construction work sites. My sober patients who return to a construction work site, we need to debrief about the caution in avoiding certain people. And I view that as a form of misconduct. And I would consider how you would want to create a culture in your workplace of not sharing pharmaceuticals. And that's challenging. And understand that one person you catch that is impaired on pharmaceuticals, there are many more people that are sharing and using sort of behind the scenes. And so the one person is sort of the tip of the iceberg. How do you react to that one person appropriately, but also create a culture where certain behaviors, because some percentage of your work output is being burned up by this behavior that's under the covers, and you're not seeing it all. So it's a challenge to change that culture of sharing pills, et cetera. But it's happening. It's one of the workplaces where it happens is construction work sites.
Yeah. Anything else? Yes.
I saw a commercial that was promoting turning in old pills. Is that big here in Minneapolis?
Let me just, so the question is there a program here in Minneapolis where people can turn in unused portions of prescriptions?
Yeah, so thank you for that. You can use the internet search for the county and pill take-back sites, and every county has many pill take-back sites where you can turn them in. Usually it's a sheriff's station or a police station, and many people either don't want to or don't have the time to go drop off their pharmaceuticals at a sheriff's station. More and more hospitals, such as Hennepin County Medical Center, are having libraries, county libraries are having pill take-back sites. So I know many libraries in the metro area, as well as hospitals and clinics, have pill take-back sites. So you can find those by internet search. There are also now commercially available charcoal bags that you can put pharmaceuticals in, put hot water in, seal them, and it inactivates and binds the pharmaceuticals. And it's not a bad idea to make available some disposal bags. They're $5 a piece, and they take pills off the street. And you just throw them in the regular garbage once you've used them. Make those available to your employees. That might be a good safety move.
And there's been a lot of discussion about making those bags available when you pick up your prescriptions too. So we
Some
may
states.
see that.
Pennsylvania,
coming
I
up.
think, mandated that.
Yeah.
I think we had a question in the back.
Yeah, our doctor was distributing those bags, and then also our police department, there's a box right in the front, and you walk in, and no questions asked, and you found yourself.
Yeah.
Yeah, just as we described.
And that's pretty much in most states. It's been a really big push to have drug take-back programs in place.
I can tell you my brother would not have been thrilled at his worst moments to go to a sheriff's station and be on 24-hour video surveillance dropping off his pharmaceuticals. Those bags work also for street drugs. You can put cocaine in one of those bags and inactivate it. So they're handy tools for those who aren't ready to go to public spaces with their pharmaceuticals.
Yeah, it's a great practical tip. One more.
I'm in construction, and the statistics you stated about construction say job site accidents and deaths. Is there a statistic on the deaths from the drug use?
And the question is, do we have statistics on the deaths from drug use itself as opposed to exit on construction sites?
So the statistic I had on my slide in 2015, that was just the Midwest, but 1,000 construction workers died in the Midwest because of opioid overdoses. So that's not necessarily they died on the construction site, but they were construction workers who passed away.
Across the United States?
I didn't find any across the United States. I only saw that statistic for the Midwest.
I know that when you start opioids in an older person, granted, you increase that person's risk of falling at home 4.5-fold. So the risk of falling is 4.5-fold increase. Now that's an older person, and construction workers tend to be younger, more robust. But there must be evidence out there, but I'm not sure. Motor vehicle accidents attributable is another example of, if they're doing a motor vehicle, they're operating heavy machinery, it's similar. Motor vehicle accidents substantially increased. Motor vehicle deaths from opioids as well. So, I don't know.
I would just add one thing, is it's not just the deaths too, to really get that full picture, you also have to look at what is your cost and workman's comp claims too. Because I have seen opioid use show up and become part of the award on workers' comp.
Thank you for all the comments. We're out of time, but we'll be around if you have any other questions. Thank you.
Thank
I
you.
want to thank our panelists and especially Dr. Reznikoff for taking time out of your busy practice.
Yeah.
It's been very valuable to all of us. Thank you very much. At this time, we're going to take a 15-minute networking break, and I'm going to ask you all to return for the final two panels, both of which are going to be engaging, and especially our last panel, my colleague Cornell Moore, who, if you haven't met Cornell, you're in for a treat. So with that, Carrot, please come back.